Hi, listeners. Welcome to a new season of Lobes and Robes. This is our fourth season, which we're very excited about. And I want to start with some really terrific news, which is that we now have a new co-host for the podcast. And as many of our listeners know, this podcast was lucky to have the support and the participation of American University neuroscientist and department chair, Dr. Terry Davidson. And he supported us and he took part as a co-host for the first 3 years of this podcast's existence. And he was really the visionary force behind American University's Interdisciplinary Center for Neuroscience Policy and Law. And that was the center that sponsored this Lobes and Robes podcast. And Terry's now retired after a very long and distinguished career. And I'm really delighted to introduce to our listeners our new co-host. And actually, this is a reintroduction because you've already heard from him, Dr. Colin Saldana, who is also a member of AU's neuroscience department and who came on our podcast last season to talk about his really fascinating work on neuroscience and the effects of sex hormones on the brain. So you can look up that episode. It was really fantastic. So Dr. Saldana holds multiple master's degrees from Columbia University and also his PhD in biopsychology from Columbia University. He was a postdoc at the Brain Research Institute of the UCLA School of Medicine, and he has a list of grants, honors, and publications that would take me hours to go through. And now he has agreed to add the directorship of the AU program on neuroscience and behavior to his many commitments and responsibilities. And along with that comes being co-host of this podcast. So his primary areas of research interest include neuroendocrinology, neuroplasticity, and neuroscience. And listeners may remember his really fascinating discussion about neuroplasticity and sex hormones and all kinds of other things that I found so informative and was so thoughtful and nuanced, and left Terry and me hoping that we could get Dr. Saldana on the podcast again. And as it happens, our wish was granted, and I'm really delighted to introduce him as the podcast's new co-host. So welcome, Colin.
Thank you.
I'm also delighted to introduce our first guest for season 4. Dr. Deborah Denno is the Arthur M. McGivney Professor of Law and founding director of the Neuroscience and Law Center at Fordham Law School. She holds a PhD in sociology with a specialty in criminology from the University of Pennsylvania, and she also has her JD from the University of Pennsylvania Law School. She clerked for the Honorable Anthony Sirica on the Federal Third Circuit Court of Appeals and worked at the law firm of Simpson, Thatcher, and Barlett before joining the Fordham Law faculty, where she too has accumulated a really long list of really important and interesting publications on the use of neuroscience in law, and especially in the criminal justice system. I've learned a lot from reading her many papers and book chapters, and I'm really glad she agreed to come on the podcast. So today we're going to be focusing on some of her recent research, tracing the use of neuroscience in criminal law over a very long period of many decades. And we also may end up talking to her about some of her other work too, which spans many topics related to neuroscience and criminal law. So welcome to the podcast, Deborah.
Well, thank you. Thank you so much, Susan and Colin, and I'm really thrilled to be here.
We're thrilled to have you. So let me kick things off by just asking if you could talk a bit to our listeners about how you came to your research focus and your interest in the intersections between criminal law and neuroscience.
Certainly, much of my career is focused on interdisciplinary analyses of crime and criminal law, and frequently through the lens of decades across people's lives. My published PhD dissertation examined path models of a vast database of subjects over 2 decades with biological and sociological variables to see who would be netted by the criminal justice system. And then I continued on with that approach when I arrived at Fordham by deciphering the origins and development of the criminal law's doctrines of insanity and consciousness. And then, lo and behold, in 2015, I founded the law school's Neuroscience and Law Center, and also starting my research on examining neuroscience up to the present time of every criminal case that's addressed neuroscientific evidence from 1900 to 2022 for over 12 decades.
Amazing.
Deborah, some of this question you've already answered, but I want to get a little more specific with you. You've published a very long list of articles and lots of important briefs. Can you explain for our listeners why neuroscience became such an interesting subtopic for you?
Sure. I mean, as a researcher and law professor with this career-long focus on the intersection of law and neuroscience, the developments and all the attention that neuroscience received really drew my interest. And I was interested in how were these insights from this emerging field affecting both prosecutors and defense attorneys? And how would stories about criminal intent change with more scientific explanations of behavior? After years of reading on the cases, I found a scholarly focus on really, pretty much small-scale empirical studies. They were very enlightening. My point is not to criticize them, but the numbers were small, and they really focused on a handful of highly unusual cases or events, either real or theoretical. So as someone who tries to work too, in the real world, I knew that neuroscientific evidence was being used much more frequently than these small numbers of cases. So I was really interested in springing forward and getting more cases and to see which ones were the quieter cases, the ones that weren't necessarily sensationalized or had a lot of funding or were focused on white middle class or upper class defendants.
Makes perfect sense. Thank you.
Yeah. So tell us what you found. I mean, you had this amazing paper where you've collected this data set of so many cases over such a long historical period. Can you summarize some of your findings about the progression of the use of neuroscience in criminal cases and the consequences of it?
Sure. And if I may, this is work that I am doing daily, as we all are. So I'll include some of my more recent findings too. But, essentially I'm finding that over these 12 decades, we have a fundamental tension between a legal system that's open to the enormous complexity of human behavior and that we know has tried to look inside the brain to understand this behavior since the early 1900s. At the same time, we have a system that blocks these efforts. So on the one hand, the criminal justice system is increasingly allowing in this evidence. I have traced that over time, over these 12 decades, and it's increasing with every single year. But at the same time, this legal system isn't allowing it to be used as effectively as it could be by either prosecutors or defense attorneys. So that's sort of my nutshell observation.
That is fascinating. So you just said something differentiating between defense counsel and prosecutors. Can you say a little more about how neuroscience and neuroscience experts are used differently between these two groups?
Sure. And, the other component that I've been finding that relates to the article that I recently published is that I define neuroscience evidence very broadly. It's just about anything having to do with the brain. So that would include neuroimaging. It would also include non-imaging tests such as IQ tests or something like that. But it also includes expert testimony. And one of my findings is that's heavily pronounced in all these cases and highly influential. And as you were saying, Colin, it's really used differently by the defense and the prosecution. So the defense generally is trying to admit neuroscientific evidence as a mitigating factor, either at the guilt phase or at the penalty phase, to suggest why someone's punishment should be less severe than the criminal justice system would typically warrant. On the other hand, prosecutors approach this evidence in basically three different ways. Number one, they typically try to eliminate the evidence. In other words, they're fighting against this evidence. They do not want it introduced into court. When it is introduced into court, they will typically, by the defense, prosecutors will try to use it to show some form of aggravation, that it's going to predict that somebody may be violent, as opposed to a mitigating factor. And they typically do that when the defense maybe isn't doing as good a job as they could be in getting this evidence in or arguing it effectively. But the third approach that prosecutors use that I found increasing over the decades is to suggest that defendants are lying, they're malingering. And actually, prosecutors use neuroscientific evidence to try to prove malingering.
That's really interesting. And are there cases where the neuroscience is such that it really goes to an individual's degree of responsibility for committing a crime?
There certainly are cases. And the other thing I have found with my research is neuroscientific evidence is used in more ways than I could have imagined. And for example, it's certainly used as mitigating evidence in a death penalty case. I think that would be pretty predictable. And that usage has definitely increased over time, particularly starting in the 90s. But for the guilt phase, neuroscientific evidence can be used in insanity cases. It's used to suggest that someone didn't have the level of mens rea that would otherwise be warranted to convict them of a higher level crime, such as premeditated or intentional murder, to try to suggest that that should be decreased down to manslaughter or that the individual should be acquitted altogether. It's used in cases of diminished capacity and competency to stand trial, but also used in other kinds of ways, such as self-defense, to suggest that someone couldn't unreasonably believe that someone was going to kill them based on some kind of brain injury or something like that. In one particular case I examined, this was a public defender who was bringing in all sorts of experts and successfully argued what would otherwise have been an intentional murder case down to manslaughter based on self-defense.
Interesting. And what is your thought, since you're an expert both in criminal law and in understanding how neuroscience is being used in criminal law? I've often wondered whether the legal definitions and standards for the insanity defense map well onto what neuroscience evidence can show, or is there kind of like a real mismatch there where it's two disciplines that can't really speak to each other very well about those questions?
I find there's a vast mismatch. I know, Susan, that you've already discussed this matter before, and particularly in your recent review of Robert Sapolsky's book in Rutgers Law Review, which I totally agreed with everything that you said. I think it's very difficult for neuroscientists, particularly if they don't have a legal background or they maybe aren't as familiar about legal doctrine and the many different types of legal doctrine, that there can be a mismatch. In my recent examination of insanity defense, particularly, I mean, here we have an insanity defense that's mostly used in this country based on the McNaughton rule that was developed in the 1800s. Talk about a mismatch between the definition of insanity legally and trying to fit neuroscientific evidence into that ancient type of definition. Perhaps for that reason, I've seen a huge decline, as has already been documented by others, from the use of insanity defense in cases involving neuroscience, which was used. Insanity was the reigning doctrine in the early 1900s, down to, very low usage, say, being offered, say, 10% of the time in more recent years. So you just see the sea change from 93% down to 10% usage. And I think a lot of that has to do with this mismatch. Here, we who study neuroscience would think this modern evidence would really be helping or guiding us closer to the truth. And it's really steering us away only because of this translation problem.
Absolutely. And does that lead to, is this motivating efforts to reform the legal definition of insanity? I mean, is there a way to use the evidence to suggest that the legal understanding needs to change to better match what science understands?
We hope that change would come about. You would think that it would, particularly since, as I have mentioned, the criminal justice system is actually open to this evidence. Much of it passes evidentiary standards, Daubert, et cetera. But you just have this blockage, and one of the blockages are legal definitions. But you don't see changes. Here we're still holding on to this basic McNaughton standard. And as far as I can tell, no vision, apart from academic debate, no vision of change.
No. Yeah, I'm no expert, but that's what I seem to see in the little bit of dabbling that I've done into this topic. Yeah.
The question that you just answered reminded me of the huge interplay that evidence in neuroscience, the interplay between experimental neuroscience, clinical neuroscience, and then expert testimony, which I believe could come from clinicians or experimental scientists. I have a couple of questions. The first one is, how much does experimental neuroscience feature in trials?
Well, that's a great question. And I think it's featured in some trials, but not very frequently. For the most part, we have expert testimony that doesn't rely on any science whatsoever. It's going to be psychiatric opinion based on interviews with the defendant, sometimes interviews with their family members, and maybe at most an examination of their past, whether or not they've had head injuries, something like that. But any kind of neuroimaging or non-imaging tests is far less pronounced. So imaging, I have found, is in less than 15% of the cases, but even neuroimaging evidence isn't used all that frequently. It's mostly psychiatric opinion. That's number one. Number two, until fairly recently, psychiatric opinion in criminal law was heavily influenced by psychoanalysis. I teach criminal law. I can see psychoanalysis used by experts in some of the cases that I teach to my students to this very day, depending on what casebook I'm using. But until the 70s, medical schools were really training their experts in a Freudian psychoanalytic approach to human behavior. And we see that in our case law. We see that in our statutes. The model penal code, which many states have adopted in full or in part, is heavily influenced by psychoanalytic approaches. So this is what we're dealing with.
That's. I was afraid that you were going to say that. But it makes sense. It absolutely makes sense. Is the lack of experimental neuroscience a problem?
I think it's a problem for several reasons. Number one, when you have experts testifying based solely on their opinion, there's no check for that. And I think this is where neuroscience can come in. Oftentimes people criticize neuroscience because they're thinking of that it's being used as a diagnostic tool. And it's really not. I'm finding in my analyses, it's typically used to validate the kind of evidence that we bring in every day into the criminal justice system. So it may validate an expert's opinion that somebody is mentally ill, or that they might have some kind of frontal lobe damage or some kind of brain damage that may have made them respond more impulsively to a certain kind of scenario than someone who did not have brain damage. It can be used to validate different types of mental illnesses, or at least give us more information on how people are thinking. One thing I have found is that we have always wanted to get inside. We as a criminal justice system have always wanted to get inside people's brains. I mean, we started using scans in the early 1920s, just X-rays of people's brains that attempt to see what's going on inside. So I think using neuroscience is just simply a way to fulfill our desire and understanding that there's more going on than just the way you can question somebody.
Yeah. And then I guess something that I'd never really completely understood or been able to get my mind around is it seems like experimental neuroscience and neuroscience generally, clinical or other, it can get to these questions. Yes, there's brain damage, and yes, brain damage would increase the tendency for impulsive behavior but it can't really explain what that behavior is going to be. It can't say, and therefore, because of that brain damage, that defendant committed the assault, right? Or can it?
I mean, you're absolutely right. It can't, and all the criticisms against neuroscience are, absolutely correct when they're making the very point that you're making. It's not going to explain causation, but it certainly can give us more information, perhaps about why somebody acted the way they did. So, for example, in the criminal justice system, when we're trying to explain human behavior, we introduce all sorts of evidence into a criminal case. We look at somebody's relationship with the victim. We look at their family background. We look at their living circumstances. We look at what kind of person they are in the community. We look at their diet. There's so many issues or factors that come into play in a criminal case. So the fact that someone may have had a brain tumor, or in one case I was examining, a third of their brain, that defendant's brain had been removed. It's not going to prove cause and effect, but it may be an additional piece of information that we would want to know about that person. That's number one. And number two, if you look at, behavior as probabilistically, which I am arguing should be done, one may conclude that maybe this would heighten the probability or the likelihood that someone would have acted impulsively. It's not causal, but it could have been a factor playing into somebody's behavior, as any one of the many other factors we look at can suggest. So this whole my brain made me do it philosophy or argument or distortion, I think it's very unfair, because as we all know, that's not a legal argument. That's sort of a media-fueled, seductive argument. But it certainly can fit into doctrinal explanations for why somebody behaved the way they did, in the way that people in the early 1900s used skull x-rays to see whether inside that person's head it looks vastly different than somebody else's.
Yeah, that makes a lot of sense. I mean, and Colin, I'm wondering, maybe you have thoughts about this too. Given the state of neuroscience today, how much power does it have in criminal law?
Again, it's really a great question. And I guess the best response is, how is it being used? So prosecutors, in addition to the arguments or the indicators I've already mentioned on how they use neuroscientific evidence, they will use neuroscience very effectively to measure the extent of a victim's brain injuries. That's one thing I've found. And the most probably effective way they have done that so far, and we've seen a lot of evidence of this, is by suggesting that there was shaken baby syndrome. So neuroscientific evidence and the brain scans that are used to suggest that shaken baby syndrome exists have been enormously influential in the criminal justice system. And it's only been relatively recently how we've realized how wrong that influence has been. And we now know that shaken baby syndrome either has been vastly distorted, or some would claim that it was a inaccurate syndrome to begin with. So that's probably been the widest, most concerning influence that neuroscientific evidence has taken. And this is very troubling. On the other hand, we do know that it also has been effective in capital cases involving defendants who are set to get the death penalty. And we know that simply by interviewing jurors. Otherwise, it can be very difficult to measure because there's so many other factors going on in a criminal case. But just simply by interviewing jurors, sometimes we know that jurors have said that particularly brain scan evidence, et cetera, has influenced their willingness to give the death penalty. But I just want to condition that statement by saying it's not that they have acquitted this person by any means. It only means that they've decided they shouldn't die, but they will still be institutionalized for the rest of their life. We do know, as I have found and mentioned in some cases, neuroscience has helped provide some bolstering for insanity defense, diminished capacity, incompetency to stand trial, down to a few cases of self-defense, et cetera. But again, it's hard to measure because so many other factors are going on here.
Yeah, and it seems to me I think bringing up shaken baby syndrome really seems like a real cautionary tale, that especially when it's used as evidence in favor of convicting someone of a crime and incarcerating them, if the scientific evidence isn't really there, it's really, very problematic to be using it prematurely. Colin, I'm really curious your thoughts on this as a neuroscientist.
I have many. So as Susan knows, I am very interested in how sex hormones, testosterone and estradiol, interact with the brain to shape behavior. And in recent months and years, there has been an explosion of functional brain imaging studies that have documented pretty dramatic changes in the cycling female brain, as well as differences between the adult female brain pre and post menopause. Now, I hasten to add that these are imaging studies. They are average differences across many, many individuals, but I can certainly see any differences being highlighted as changes in the probability that an individual may perform a certain behavior. Are there some checks and measures in place to prevent that from happening, Deborah?
Yes, Colin, could I just ask for a clarification? Checks and measures to prevent the use of hormones or...
No, sorry. Checks and measures against, it's a very good clarification. Checks and measures against using average data to argue about culpability for an individual person.
Well, it's a wonderful question. I mean, this is the whole group versus individual dilemma that probably in all the cases that we're looking at, we're using average data to try to figure out individual behavior. And it certainly is problematic. And that's done with brain scans too. And at the same time, on the other hand, I think it's also important to get a baseline standard for how these measures could influence human behavior. So, for example, the only way, as far as I can tell, that we know that hormonal differences or brain damage differences, et cetera, exist at all and that they can have any link to human behavior is by looking at groups. Large, vast numbers of groups. I mean, that's what I'm doing now, as opposed to individual cases. So on the one hand, we need that information, determine whether this individual can even be considered to be making an argument that it affected their behavior. What do you say? Well, how does it work in groups? What have we found with standard measures? We see that even with the standard, Stanford Binet or any kind of IQ test. So one of the biggest arguments, for example, against using MRI in the courtroom is you don't have these standardized measures. MRI really wasn't fully standardized as far as my understanding until relatively recently. So you have that argument going on, but at the same time, you have the argument saying, well, simply because this individual shows a deviation, what does that say about them? We know what it sort of says about the group, but what does it say about them? Because they're an entirely different person. And I guess my argument is the strongest gauge and measure we have of individuals' behavior is two-pronged. Number one is have they acted in the past? Are they deviating from their past behavior before they had the hormones or before they had the brain damage? But number two, what does group behavior look like? Because otherwise, we can't answer that question. So it's sort of a catch-22. I understand that argument, and it's a very valid and feasible argument. At the same time, when you look at science, the whole point of science and getting large sample sizes, et cetera, is so that we can form some kind of conclusion or consensus.
Yeah, that makes sense. I don't know, but Colin, what do you think about this, growing use of neuroscience in individual criminal cases? Are we out in front of our skis in doing that?
I think the best way to answer your question is to ask how other scientific fields have been used before neuroscience. And, the medical field has been, again, clinical, not experimental, but clinical medicine has had considerable success, I would think, in courts of law. Evidence, I can only imagine that there's not a large group that questions medical data or information as much as they do experimental information. So I don't know if we're getting ahead of ourselves per se right now, but I do think we have to be very, very careful. Arguments like this person has an abnormally high level of circulating testosterone. So what does that mean? Does it mean that this person is aggressive? No. Does it mean that this person is hyperactive? Not really. So it's those inferences that I think need to be made and examined very carefully.
I agree with you really 100%, Colin. I mean, first of all, I think we need to answer the compared to what question. To say that neuroscience is ahead of itself or the criminal justice system is ahead of itself, we need to consider what it's using right now. And that's bad science. If it's a choice between neuroscience and psychoanalytic science, or what we were using in the 60s and 70s, I would say we should be using what's acceptable today. Secondly, there's really a due process argument to suggest that we should be using what's acceptable in modern medical science right now in the criminal justice system. It's not that we're ahead of ourselves. We're just the criminal law should be operating in real time. We're going to make mistakes, as the medical field does, or as the psychological field does, maybe 20, 30 years from now. We'll find that we're making conclusions that are inaccurate right now, but this is how medicine and science operate. No scientist is going to say that what's being done today is not going to be improved upon or maybe even corrected in the future. And to treat the legal system any differently, I think is a gross injustice to the defendants before us right now.
Yeah, I think the rules should be different as between prosecution and defense, because it's going to be really hard to tell defendants who've been convicted of shaking babies that didn't do it after they've been in jail for in prison for some amount of time that, now we know the science we used to convict you is incorrect. So that seems also something, really important in the criminal justice system that is unique because of the different burden of proof between prosecution and defense.
Yeah, I think you're absolutely right.
Yeah. Also fascinating. I hate being the one who always has to say this, but we're starting to run out of time. So could you tell us a little bit about, you have a forthcoming book and you're involved in so many future projects, just, what your future direction is going to be?
So I think, I mean, I'm still looking at this database, but the central question I'm trying to answer is why in the almost 120 years that's the focus of my research of scientific evidence in the courts, why again, the courts are willing to accept and comprehend the strength and limitations of neuroscientific evidence, but the defense and prosecution aren't using it more often and more effectively. So it seems like the law hasn't lived up to its promises of using modern neuroscience or modern science, and we do have that stated. I have in my book, I start out with a 1922 case, insanity case, and I end with the Collar v. Kansas 2020 insanity case with almost identical quotes. And those identical quotes are that law should be relying on modern science to make determinations about what people are thinking. But that's simply not happening. The law is promising that in writing, but it's not following up on that. And what happens is we deal with these distortions and myths that are generated either by the media or the public or, the legal system itself. The brain made me do it. This double-edged sword, either people are getting off in the criminal justice system because of neuroscience, or they're being treated worse than they ever would be otherwise. The punishments being aggravated. And really the point of this book is to argue against those myths and try to have enough information. I have over 9,000 cases to suggest that when you look at this body, these average cases, not the highly publicized, sensationalized cases, but the everyday cases, that neuroscience is actually a very useful tool, and it could be used far more effectively than it has been.
That sounds like a wonderful project. I can hardly wait to read the book and continue to follow all your prolific publishing endeavors.
And it's mutual. I looked at both of you, and you've just got both done incredible work. So it's a real honor and thrill to be here. Thank you so much.
Our pleasure, Deborah. Thank you so much for taking up our invitation.